Well, hello everybody, and a very warm welcome to this Gowling WLG webinar. It's just clicked into the afternoon, so good afternoon. Welcome to what is our second webinar in our series of Scheme Sessions Volume 1 2022. Last week in our first webinar, we were fortunate to have Sarah Horan of ITS and Louise Sivia of the Pensions Regulator. And we discussed governance and what's new, in particular, the single code and diversity and inclusion. And when we've completed our series of webinars, each of them will be available to look at if you did miss it through a download video. Next week, we will have our third and final webinar where we'll be looking at back to basics on governance. We'll have Charlotte Scholes from Gowling and Nick Hill from Outer Chambers talking to us about good practice in record keeping, minutes and documentation and so on. And today's topic is the new transfer regime. I'm delighted to have Margaret and Maddie with us today, who I'll introduce a little more in a moment. So just a quick bit of housekeeping. So in terms of the format for this session, we'll be asking Margaret and Maddie to talk to us for a short while. They'll be doing a short presentation, and then we'll open up to Q&A. We'll be aiming to wrap up somewhere between 12:45 and 1 p.m. You should see at the bottoms of your screen the Q&A button, so please feel free to put any questions through to us as the presentations come through at any stage, and I'll be watching out into the inbox to see what questions are coming in, and we'll try and pick up as many as we can. As always, there's an opportunity for feedback at the end, and we're always really grateful to any feedback you can give us. Could fill in the short form at the end. We'd be very grateful indeed. So to today's topic, the new transfer regime. Transfers from pension schemes have long been a topic that we've all been grappling with, both in terms of protecting members and also protecting trustees. We've had new regulations come through, and we'll be talking about those this morning. And we're absolutely delighted to have Margaret Snowdon with us today, alongside Maddie from Gowling. Now, Margaret has probably one of the most impressive CVs of anyone in the pensions industry, and I only need to mention a few things alongside her OBE. Top 50 influential people in pensions, Pensions Personality of the Year, top 100 women in finance, and an industry champion, just to name a few. So this is as close as I get to pensions royalty, and it's fantastic to have Margaret here. And even more importantly for today's purposes, Margaret's been at the centre of the transfer world and the regulation and protecting members against scams. So we're absolutely delighted to have Margaret with us this afternoon. And alongside Margaret is Maddie Frost. So Maddie's a very experienced legal director with us here at Gowling, and Maddie's part of the leadership team for what we call our scheme advisory pillar. Maddie advises trustees on all aspects of pensions law, but has been giving a lot of our clients advice on this very topic over recent weeks. So again, is a perfect person for us to have this for this session. So that's plenty from me. Delighted to have Margaret and Maddie here. I'll be looking out for your questions as you put them through, and hand over to Maddie.
Yep, thank you, Jason. Joy, if we can just stick to the agenda. Thank you very much, the agenda slide. So good afternoon, everyone, and thank you for joining us. As Jason said, in today's session, we are going to be talking about the new conditions of transfer regulations, which came into force with some haste on the 30th of November last year, and are applicable to transfers out of pension schemes requested by members from that date. I'm also very happy to have Margaret joining me for this session, and in a moment I'm going to pass over to her, as she is perfectly placed as chair of the Pension Scam Industry Group to put this session into context for us by reminding us what actually is a pension scam, why are they such big news, and why members may need protecting from them. I'm then going to run through what the regulations actually say. I'm sure you'll be very relieved to hear I'm planning on doing that pretty quickly, leaving plenty of time for Margaret to give her view as to the regulations as they've landed are actually consistent with DWP's policy intent behind them. and also to comment on how they've been received by the pensions industry. We will then turn to look at some practical issues that have arisen from the regulations and how we hope some of the problems will be resolved. And then at the end, as Jason said, leave lots of time for questions. So briefly, just to introduce the topic, the regulations. Now, the aim of the regulations is, of course, to protect members from pension scams. It's been highly publicised that members have been caught out by scams and sadly lost their entire pension savings. Of course, trustees don't want this to happen. No one wants this to happen. But what the regulations do is to put the onus on trustees or managers, although I will probably refer to them as trustees as I go through, to carry out checks before enabling a member to proceed with a transfer that the member himself has requested. Now, the new requirements apply to statutory transfer requests by members of both DB and DC, occupational and personal pension schemes in both the public and the private sector. So if the trustees or managers of these types of schemes are not satisfied that the prescribed conditions are met, the member's previously absolute right to transfer his or her pension benefits is lost. Now, this immediately sounds like quite a lot to put on the shoulders of trustees, and this is in addition to ensuring that the current transfer requirements are met. So the requirements that already existed for DB transfers over £30,000 in order to access flexible benefits, that still applies, as does the statutory timeframes for complying with transfer requests. But that's enough of me by way of introduction. I'm going to pass over to Margaret now, who is going to look at what is a pension scam. Thank you, Margaret.
Thanks, Maddie, and good afternoon, everyone. I thought it might be useful to look at the definition of a pension scam, because it's quite important that we know what we're trying to protect against and why. Now, the definition is up on the screen at the moment, and I don't expect you to read it all, but there are a couple of key points. One being marketing, which means publishing, publicising, trying to entreat people to do something. And it's also whether it's successful or not. So it can be an unsuccessful attempt and it's still, a scam. And as far as we're concerned, it's transfers from HMRC regulated pension schemes. But there are various ways that that can happen. But one of the key points is a scammer has to be misleading. So if a scammer tells you something that, is quite true, then that's not, you're not being misled, but it's the fact that you're being misled about the risks you face, about the fees you charge, etc. That's the key point that makes it a scam. But we hear all the time about scams being now investment scams rather than pension scams, that implying that pension scams are no longer a problem. So we need to consider whether we need to change the definition to make it a little bit clearer. And particularly the problem is with law enforcement, because they'll only go where there seems to be a big problem. And if we don't signal a problem with pension scams, then they will focus on something else, whether it's romance scams or whether indeed it is investment scams. So we need to be able to show what we're trying to protect against, and then basically check that we're actually doing that. So we have to think about whether we want to extend or narrow down that definition. So that's something PSIG is working on at the moment, and working with Bloom to try and see if we can do anything. And one thing we're looking at is actually trying to find a way to extend it into investments that are made by people after they've taken money from a pension scheme. The key for us is whether the source of the money is a pension scheme, but it's quite possible that it's one step removed by somebody taking cash from the pension scheme and then giving it to a scammer. Now we need to make a clear position on that, whether we think schemes who have got no power to dictate what people do with their money, whether we try to intervene in that or not. But it's important to distinguish between scams and unsuitable transfers. A lot of what goes on is actually unsuitable. It's not necessarily a scam. It's just not the best thing for an individual to do. But, you know, it's not a pension trustee or provider's job to try and, you know, dictate what individuals can do. FCA is, you know, there to try and make sure the standards, the quality of advice, financial advice, is good enough. So we need to be sure that we're not trying to solve every problem in the universe with limited resources. So I'll move onwards, just to give you a little flavour of the scale of pension scamming and why we need to home in on it and why we need to do as much as we can to prevent it. And to put it into perspective, 60 billion is the number of transfer requests received in a typical year. That's a hell of a lot of transfer requests. Now, they don't all go ahead for various reasons, but round about half do. So that's £30 billion worth of money leaving pension schemes. Scary amount. Now, I've said, you know, around about sort of 10 billion has been scammed since about 2015, and that's a frighteningly large number, and it's nowhere near the number that's being officially quoted because we have no stats, we've got no information on that. But typically £1.5 billion is being scammed from pension schemes through transfers in a typical year. And that's, you know, between 6,000 and 10,000 people, which is important to bear in mind. And I've got 50% up, you can hardly see it, but 50% really is the pension population who would not spot a scam staring them in the face. And that means, you know, we've got quite a lot to do to try and stop things, you know, deteriorating and disadvantaging people. So I'll hand back to Maddie, who will give us the good news or the bad news on the regulations and what needs to be done.
Thank you, Margaret. So the regulations, now the process set out in the regulations is quite specific and quite detailed. And as I mentioned at the outset, could ultimately lead to the trustee deciding that the member has lost their statutory transfer right. Now, the first step in this process is for the trustees of the transferring scheme to notify the member within 1 month of the transfer request that the transfer cannot actually go ahead until the trustees make a decision that one of two conditions is met. And TPR, I should also say at the outset, TPR has issued some new guidance, and in that guidance, it sets out what, as a minimum, trustees should ask for. And to be honest, this is a kind of statement of the obvious. It's the member's name and address, information about the receiving scheme, and information about the IFA and any other individual involved in the transfer. But having done that, the trustee must then consider if the first condition is met. And there on slide 9, you'll see that, dare I say, this is the easy part. If the first condition is met, it is met if the transferring trustee is satisfied beyond reasonable doubt. I'll look at what that means in a moment, that the transfer is to a receiving scheme that is either a public service scheme, an authorised master trust on TPR's list, or when we have them, an authorised collective money purchase scheme. Now, here we have the higher beyond reasonable doubt standard of proof, which is the proof burden of proof often used in criminal cases, as opposed to the civil standard, the one that the trustees will be more used to on the balance of probabilities. I think, however, that given it should be pretty clear whether the receiving scheme is one of those listed, this actually shouldn't be too onerous for trustees to determine. The trustee just must not have a reasonable doubt that the receiving arrangement is a public service scheme or actually is a master trust. So if the trustee is satisfied, the transfer can proceed and consideration of these regulations is over. of course, subject to complying with the existing requirements under the existing transfer regime. Now, it gets a little bit more complicated. We flick to slide 10, if the first condition is not actually met. So if the first condition is not met, the trustee then has to determine if the second condition is met, which means an assessment of the existence of red and amber flags. If there are no red or amber flags, the transfer may proceed and the member will be informed. If there are red flags, the transfer may not proceed and the member must be told within 7 working days of that decision. If there are no red flags, but there are amber flags, the trustee must require the member to seek guidance from the Money and Pensions Services. And that itself will raise some issues that we will discuss a bit later on in the session. So they must seek this guidance and also then provide evidence to the trustee confirming that they have taken this guidance. However, it is only a red flag then if they fail to provide this evidence and the transfer may not proceed. So if we click onto slide 11, let's start thinking about what these flags are. So in order to carry out an assessment of flags, first the trustee needs to know if the transfer to an occupational pension scheme or a qualifying registered overseas pension scheme, so an OPS or a QOPS. If the transfer is to an OPS, the trustee needs to request evidence of an employment link. If the receiving scheme is a QOPS that is not an OPS, the trustee must request evidence to demonstrate a residency link. Where the receiving scheme is a QOPS that is an occupational pension scheme, they can request evidence to demonstrate either link. So both the employment and the residency link are intended to establish the legitimacy of the transfer by evidencing that link between the member and the scheme the member wants to transfer to. I think the employment link is particularly interesting. I think it's to address the position decided in a High Court judgment where it was deemed that although the member had earnings, they didn't actually have to be paid by an employer in relation to the scheme. So I think the intention of the regs here is to demonstrate that real employment link. And in order to establish that, the trustee should be satisfied that the member's employer is a sponsoring employer of the receiving scheme, that the member's worked there for at least 3 months and has received pay for doing so, and has paid contributions to that scheme. Establishing the residency link will be different because the evidence that will be required may vary depending on the country in which the member needs to demonstrate he or she is resident in. TPR guidance then sets out the evidence that the trustee should request to establish these links, and I don't propose to go into that in any detail at the moment. But there, of course, is a fourth scenario, and that's the transfer is to an arrangement that is not an occupational pension scheme or a qualified overseas pension scheme, and in which case the trustee then has the ability to decide what information, if any, that it requests to determine whether there are any red or amber flags. So before I look at what the other red and amber flags are, I just want to note the process on the next slide, which is it is only if a substantive response to the trustee's call for evidence of an employment link or a residency link is not received that a red flag is raised. If an employment or residency link is not established, this is an amber flag, and in itself, provided that the member does go and get MAPS advice and that this is evidence, would not mean in itself that the trustee could stop the transfer. Also, if an employment or residency link is established for an OPT or a QOPS, the trustee must also look for other red or amber flags before the second condition can be satisfied. So looking for an employment link or a residency link is not necessarily the end of the story. So going on to these flags, slide 13 sets out what the red flags are. And of course, this means the transfer may not proceed. Now, the first 2 red flags must be decided by the trustee beyond reasonable doubt. This means that the trustee must have no reasonable doubt that the member has failed to provide a substantive response to the request for evidence of information. So the trustee has asked for residency, employment link, or other information, and the member has not provided a substantive response to that request. A substantive response means, and this is specified in the regulations, to provide at least part of the evidence or information requested. So before the trustee can deem this failure a red flag, it must send a reminder to the member at least 1 month after the initial request, and then a further reminder after a further month. It's also will be a red flag that the trustee must decide beyond reasonable doubt if the member has failed to provide evidence that he or she has taken MAPS guidance. I expect that actually that the trustees will determine this only if the member has not provided any evidence to the trustee's request and hasn't provided a reference number that will be given by MAP. So that should be relatively easy for the trustees to determine. There are other red flags. Joy, please can you pass to the next slide? Thank you. There are other red flags listed on the slide there. I think these are all the things that will generally raise alarm bells for trustees, that there's a transfer to a scam arrangement. So an unregulated person has carried out a regulated activity. The member has been contacted by someone out of the blue, been offered an incentive to transfer, or that the member may have been pressurised into requesting a transfer. Now, in deciding if these red flags are present, the trustee only needs to have a reason to believe that the flag is present. And this means having a reasonable foundation for the belief based on the evidence available. And this is a lower standard. And I suggest that this would actually cover any valid suspicion that the trustee would have that one of those red flags is present, which I think is actually quite important, because the trustee will probably never be able to get certainty on some of these things, because it's inevitably relying on what the member tells the trustee. It won't otherwise know if there's been, say, unsolicited contact, or the member has been incentivized to make this transfer. So on the next slide, we set out the amber flags. Now, if these are present, the member must seek advice from MAPS. The first is that the trustee has been provided with a substantive response to its request for information. So it has been provided with some information from the member, but it's incomplete. And this must be decided beyond reasonable doubt, meaning the trustee must be pretty certain that the information is incomplete. In deciding if the other amber flags are present, the trustee must decide if they have reason to believe they are present. So evidence is either not provided by the member, or they don't believe it to be genuine. The employment or residency link is not demonstrated to the satisfaction of the trustee. There's high risk or unregulated investments in the receiving scheme, unclear or high fees charged by the receiving scheme, whether the investments are complex, unclear, or unorthodox. If there is any overseas investment included in the receiving scheme, we will be coming back to that one a bit later in today's session. And also if there's any sharp and unusual rise in requests that seem to have come from the same firm of advisors or to a particular scheme. Now, going through that list, there are a number of terms here for the trustee to consider: high risk, high fees, unorthodox, which are all defined in the regulations, but only by reference to a comparison of what would be considered normal or in a normal range. So it's going to be for trustees with their advisors to consider how these terms are defined more exactly for them. So I think that's enough from me, the whistle-stop tour of what the regulations say. I'm going to pass back to Margaret now, who is going to look at the extent to which DWP's policy intent has been met and to touch on some of the practical issues. Thank you.
Thanks, Maddie. Phew, that's quite a trot through very complicated regulations. It's interesting to look at the DWP policy intent, what they meant to happen. And it's actually quite clear. DWP was responding to requests from PSIG, from various other bodies, from the Working Pensions Committee as well, to bring in some legislation to try and help trustees and providers stop pension scams. And Maddie alluded to, the Hughes case earlier when she was talking, where it became very clear that it was very difficult for trustees to refuse a transfer where there was a statutory right. So DWP, thought about it, worked with us for quite a bit of time to come up with what they intended. But the headline intention is they wanted to provide a tool to trustees and providers to allow them to stop dodgy transfers. We were continually telling DWP that trustees had their hands tied behind their backs. And as long as there was a statutory right, which is a very strong right, it was very difficult for them to defy that. So, the purpose behind the regulations is to do just that. It's not to increase the workload of trustees, schemes, administrators, but it is to try and give you what you might call a tool of last resort, to be able to say, no, I don't like this. I've got various flags coming up, therefore I'm going to stop it. And for the first time, trustees will be pretty safe if they do that. Now, it's one thing, to set out lots of amber, red flags. PSIG has been doing it for a few years, but it's quite difficult to code it for regulatory purposes. It was quite a painful process, but it was actually a very rapid process in the scheme of things. So there are a couple of things that don't quite work. And we'll be trying to find ways to make it work, because what we don't want is, we don't want people to go, oh, this is just too hard, it really hasn't done the job, therefore we'll disregard it. Or it really encourages us to take minute actions all the time, therefore we'll just get in the way of every single transfer and slow down the whole process. Both of those would be a failure, and it would be a disregarding of a gift, in a sense, that's been given an opportunity to stop pension scams. So we do need to try and make it workable. One thing I would say is, I mentioned the statutory right, and the regulations only affect the statutory right. They only remove the statutory right if conditions aren't met, but they don't interfere at all in drawdown transfers, because they're not subject to a statutory right. They don't affect the majority of partial transfers, and of course they don't affect discretionary transfers. All they do is say that if certain conditions aren't met, then a statutory right doesn't exist. So we need to try and keep it in context. But, basically, if you were happy to transfer to a particular scheme in the past, there's no real reason why you wouldn't continue to be content to do that. But you do have to justify your decisions. There's no question it's tricky. There's no question, there's sometimes a little bit of a rigmarole to go through. Lots of schemes have been doing this themselves already, but they've now got something that justifies them doing it, because it can lead to a refusal to transfer. But, the big question will be, how will this all play out? And unfortunately, we'll only know in the long term how it plays out. I think, we really do need to do our best to comply and be reasonable. And the big test will come with the Pensions Ombudsman. And if he doesn't like what you've done, and what he won't like is people making no attempt to try and discover whether a transfer is right or not, you'll lose if you don't do any due diligence. But he's highly unlikely to find against you if you have done due diligence. And he's proved that in the past, where he's tried to support pension schemes' efforts, but the courts overruled, and that's what happened in the Hughes case. So the big test will actually be when we get to a court case around this, and that will be possibly 3 years down the line, by which time we all know the DWP policy intent. We know there are a couple of wriggly bits within the regulations that don't help, but those inconsistencies will be clarified, and they'll be clarified before anything gets near the court. That's my view on it. But it's still an issue, and we've still got things to do. There are new notification requirements, a couple of extra bits of admin, which boil down to good practice, but yet it's not what everybody does. So sort of moving onwards, I'll look at a couple of practical tips. But first of all, some of the things we're hearing from the industry is that administrators are referring a lot of cases now to trustees. They seem to have lost their confidence in looking at transfers and trying to decide whether ones are at risk of scam or not. So they're passing the buck a little bit to the trustees, leaving them with the problem, which of course means that trustees are more tempted to pass it onwards to the lawyers. So somebody else gets to carry the can to try and decide whether this is a fair transfer or not. But also we've got a lot of responses that show that people think this is a good thing. They really like the principle of having a tool to be able to refuse and not worry that then some claims management company is going to come and pursue them for restitution. A lot of schemes, though, are not making changes at the moment because they're not quite sure what they have to do. And we need to make sure that that message is heard. And some are referring a lot of cases to money helper already. And that's because they're not sure, therefore err on the side of caution and refer cases to money helper. Now at the moment it's not a burden for money helper because they are resourced to deal with a targeted number of cases, but it does tend to be the same firms who are making those referrals to money helper. I think the money helper guidance is being appreciated, but obviously there's a risk it could be swamped if everybody just takes that view. But a lot of other schemes, and particularly ones in the contract space, insured schemes, personal pensions, etc., they transfer on a discretionary basis. So, they're not impacted by this at all, except, they've got to make sure that even in discretionary cases, they apply good scrutiny, good due diligence processes. But a lot of personal pension transfers are from insurer to insurer. So they're seen as a little bit safer, and the insurance companies are happy to transfer those on a discretionary basis. So in terms of how you go around this, I've said it's not a detective story. You're not expected, to become Hercule Poirot and try and, drill down and find out who the bad guys are, etc. It is largely on balance of probability. Now, listening to Maddie, she rightly points out that there are different levels of proof required for different bits. That's a bit unfortunate because it does actually confuse people. But I think a rule of thumb is think about it as, what a reasonable person would conclude with the information they've got. And that's a non-lawyer's response, and I don't have to be responsible for any outcome. So I can say that. But it has to be proportionate, and the DWP intended it to be proportionate. They look at it the way PSIG does, which is 95% of transfers are unlikely to be scams. So don't apply, the tight tests to every single transfer, or you'll have a very bad outcome. And you could have a very bad outcome for delaying a transfer, as well as for transferring to somewhere that's a bit risky. So we can rely on trusted transfers, whether they're because you transfer to certain places regularly and you do check that they're not cloned, they're not impersonations. So you can transfer to places you know very well without having to redo the due diligence. You can use clean lists, green lists, whatever you want to call them, as long as they're up to date. And as long as something hasn't fallen over in the 2 years since you last looked at your list. And I mentioned already discretionary transfers, they can continue. You just have to make sure that you don't do it as a lazy alternative to looking for the statutory right to transfer. And another point is, there's a lot of commonality regardless of which approach you might want to take. And what PSIG is doing right now is trying to come up with the common touch points to try and make the process a little bit more straightforward, and also to include templates, to look at the timing. And, Maddie mentioned notification of conditions to, the transfer member, but you can think about that a little bit creatively. And the way the regulations are worded is that it says notification of the condition used has to be made before the member is notified the transfer has been received. Now that means, to a purist and a non-lawyer, that's very much, if you don't ever tell the individual that a transfer has been made or received, then there isn't any notification of the condition required. But the easy way around it is for a notification of condition to be given by the receiving scheme, so that when they, and if they, say that a transfer has been received, it's very easy for them to say whether it's under condition 1 or condition 2. If it's condition 1, they'll know it because they will be a condition 1 scheme. And if it's a condition 2, and it's very obvious that they're not a master trust, they're not a public service scheme, etc. Therefore, it has to have been under condition 2. So that's a workaround, and that's the sort of thing PSIG is grappling with at the moment. But I'll sort of leave this slide on the thought that 95% of transfers are not scams. The 5% that are worth $1.5 billion, and they're the ones that we want to stop. So I'll hand back to Maddie, who's going to look a little bit at one of those wrinkles and wrinkly bits that I mentioned.
Thank you. Yeah, I'm sure you won't have failed to notice this. So when looking at the amber flags, I actually mentioned that one such flag is if there are overseas investments by the receiving scheme. Now, if there are, this is an amber flag, which means the member has to go and seek guidance. Now, clearly, most receiving schemes will trigger this flag, and MAPs will be very busy, and this does not seem to be practical. We're all up for finding pragmatic solutions. However, having looked at the words of the regulations, they are pretty clear, and they don't seem to give a discretion or any element of risk assessment in this requirement. Now, while TPR guidance does suggest that trustees should be taking a risk-based approach, there's nothing specific in the guidance on this point to act as protection for trustees. And it doesn't seem that the wording leaves any room for the trustees to exercise its discretion and take a risk-based approach. Now, I appreciate the practical issues that this may cause, although while the regulations say what they say, I think it's difficult to see how the trustee can take a pragmatic approach. And this is something that we hope will be ironed out sooner rather than later. And that was all I was going to say on that point. I'm going to pass back to Margaret, who's going to look at some of this unfinished business.
Margaret, you're just on mute.
I knew I'd do that. Oh, I do it in every single meeting. I don't know why. But anyway, there we go. Unfinished business. Maddie very rightly pointed out, the dilemma we have, because, trustees have to follow the law. The courts have to follow the law. The Ombudsman has to follow the law, but the Ombudsman can take into account good practice. And that's why I mentioned earlier that the crunch for a lot of this will actually be anything that comes to the court. And I like to think that, the wrinkles like the very clear one on investments overseas will be resolved within that time. And it's come about, I mean, we did actually point out to DWP before the regulations were laid that this, which was a last minute change actually, was going to cause a lot of difficulty. And they were under a tight deadline to get things done, and they couldn't see how they could get around it. I mean, we as non-lawyers can say, well, all you need to do is change the definition of an overseas investment. But that's quite difficult to get through all of the process. So we're kind of stuck with that at the moment, and to try and get around that, TPR issued guidance that said, no, look at it in a risk basis, which is fine, but it's still not statutory. So Andy's right, there is a problem, but we'll, in the short term, I think we get around it by taking a risk-based approach. But in the medium to longer term, we do have to solve the problem. DWP has undertaken to review the legislation in 18 months. They might do it a little bit sooner than that, which will give us a chance to head off potential issues, particularly issues with the court. But it's a wrinkle we could have done without, actually, and arguably, I mean, I think personally I found it was a little bit like snatching defeat from the joys of victory, because it worked very well until that very last minute legal blip. But we'll get that resolved. I'm quite confident that we will. In the meantime, we're looking to publish version 3 of the code that will take these little wrinkles. The overseas investments isn't the only one. There are a couple of other bits and pieces. So we'll be trying to help navigate that with a sort of sensible, pragmatic solution, bearing in mind the wall could come tumbling down, but let's not tumble it down ourselves first, is what I would say. Other things we still need to do is we do need to gather information on transfers, because while we guess what the problem is, while we base it on samples and extrapolate from that, we're still not getting the real traction, and we need to do better. So PSIG again is looking at what MI might be sensible to gather. And also, scams aren't reported. They're not reported by people because they don't like to report it, particularly as there is a potential for a tax penalty. So people don't like to admit that they've been scammed, and schemes don't like to report it either. So we've got a definite underreporting problem. So we need to solve that. But one of the biggest problems is actually the way that scammers get to people. And today they get to people through online adverts. Some of them are impersonation, and some of them are just outright lies and traps to catch people. But online financial harm is easy because there aren't any controls over it. Now, we've been trying very hard, along with others, to have the online harms or online safety bill changed, and there's a little chink of light in that it might be in a couple of the social media platforms. Search engines have already said they will look at people who are placing financial adverts, but that's a voluntary thing that some of them are doing. I mentioned tax penalties, and we still are pushing Treasury to think about a tax law change to stop penalising people who've been cheated and scammed into doing something they wouldn't otherwise do. They're not quite the same as people who go into, you know, some tax dodges, you know, whether it's, you know, loan schemes or whether it's, you know, film investments or whatever. There are lots of examples. Pension scam victims are not in that league at all, but they're still being punished, and we want to stop that. And my final point really is we want to try and make it easier for bad guys to be spotted. And we believe that we need an intelligence database for practitioners to use to put in the names of dodgy providers, to, you know, be able to look at it and see if a scheme name looks like a dodgy one, if it's on the list. It's a dangerous thing to do, but there is quite a lot of open source data that can actually be input and used. And, you know, we really feel that that ought to happen. We're working with Project Bloom to see whether it's something that we do ourselves for the industry, because we have a lot of intelligence. We gather it through our you know, sort of forum, but it takes a bit of money. So unless we can get some money from the industry, it will be very difficult. But that's sort of all I wanted to say on that, but happy to answer any questions that come along.
Brilliant, thanks very much, Mark and Maddie, for that comprehensive presentation into both what the regulations are telling us and also the background context to it all. We've had a number of questions in and I'll try and get through as many of them as I can. Apologies if we don't get to your question. Probably what I'll try and do is just group them into some themes and put them to Margaret and Maddie. So most of the questions are understandably very practical ones as to how to deal with this, and perhaps the first theme I could pick up from the questions is around timing and delays and the amount of work that will need to go into this. So a question, maybe Maddie, first to you, in terms of, do we expect trustees to have to be more flexible with guarantee periods, with the time periods in which they're going to be able to comply with the requirements here, and how do they deal with this sort of conundrum between members pressuring because they want transfers made and on the other hand having to do this protection?
I think it's going to be one of the key issues that trustees are going to have to look at. I mean, there is an increased onus on the trustees to almost protect the members from themselves, and there's still going to be the obligations to deal with these transfers within a prescribed period of time. The trustees may well want more flexibility, but there's only a certain amount of flexibility within to give the member what they want within the remit of the regulations. So I think this will be something that trustees, at least initially, will find quite tricky until the processes are bedded down and that they can almost smooth out the amber flag processes to be able to focus on the red flag processes, so that it ultimately, hopefully, won't be too much of an additional burden.
Thanks, Margaret.
Yeah, I would agree with that. And I know it's new and it's therefore a little bit tricky, but I'd come back to the point that we're looking at only a small proportion of all the transfers that are being dealt with by administrators, trustees, providers on a daily basis. So it's not looking at all of them, but sometimes that's difficult, you know, to look at the ones, all of them and decide which ones you want to spend your time on. But it may well need some extension of guarantee periods, but I think not. But, I think it's down to us helping the industry to be as efficient as possible, so that those resources aren't squandered. But it will come down to a level of confidence, and it's not there yet.
Thanks, Margaret. And just picking up that sort of theme, and we're getting some questions about this, which is that trustees are a bit stuck because they could be challenged both if they don't sort of spot a scam and let something through, but equally members who are confident about where they want to take their money, not being able to take their money somewhere. So a question we're sort of getting is how does the trustees protect themselves from the challenges from members, you know, saying you're just not moving fast enough, or there's a delay, or you're going to cause me some loss there. Maddie, what's the sort of way in which trustees should record what they're doing here?
So I think we need to recognise actually that there's already lots of complaints to the Pensions Ombudsman about transfers, and the fact that there's a delay in processing transfers does lead to member claims that they've suffered a loss as a result. I think the trustee will need to show that it's acted in accordance with the regulations, that there hasn't been maladministration. I think the Pensions Ombudsman will apply the same standards to that as it currently does. I think that the interesting thing will be not only, you know, members who have still lost all their money because a scam was let through, but as you say, members who have been red flagged, so to speak, and then have the complaint that actually I've completely lost out here. I wanted to make this transfer and I missed the boat. But I think you just have to take comfort in the fact that actually the regulations might help trustees and put them in a better position than they are currently, because they're more prescriptive on what is expected of trustees to do, and provided that they do those things, they should be protected from challenge. And
I would just add, again, I think it's down to some practical solutions and things like, well, if a member asks for a transfer, you know, why not tell them at the outset that this various, you know, information is going to be needed, and, you know, encourage him to, you know, get that information and proof and evidence that's needed up front, rather than have it as an iterative process which takes ages. But you know, I agree with Maddie. It's a difficult one. You feel as if you're damned if you do and you're damned if you don't, but you have to act reasonably, and I said you're not expected, you know, to be Hercule Poirot.
We've had quite a few questions around the overseas issue that you mentioned, Maddie, and I think first point for me, just to pick up on a couple of the questions, is that this overseas issue does unfortunately hit a larger number of transfers than we might have hoped, because of the way that the regs were finally changed. So if something is an occupational pension scheme or a QROPS, it kind of falls into this issue, unfortunately. So it's quite a wide net. One of the questioners has asked, would you see it as proportionate and reasonable to overcome this issue, which is, from what we're hearing from TPR, is just not one that was intended, by effectively allowing people to, if either go to MAPS and you go through this statutory process and they provide evidence, or if there starts to become a backlog with MAPS, use a non-statutory process whereby you kind of go, well, everything else we've done by the book of these regs. The one thing that the member hasn't gone to do is go to MAPS because there's a backlog, but we're going to go with that and that's okay. You know, would that be a practical way forward, or is that an uncomfortable thing for trustees to be doing? Maddie, maybe start with you.
Okay, so I'm obviously going to give this the lawyer's view on it. That sounds like an entirely reasonable thing to do, doesn't it? I mean, trustees, everything else has been done. MAPS is a bit busy, but I suppose you have to think about, why would the trustee take that risk? Why would they? There would be a clear challenge to them that they haven't done something that they are required to do by law. And in the 95% of cases, that might be fine, and you'll never hear about it again. But what if you do get those pocket of cases? It'll be so clear that the trustee hasn't done something that it was required to do. I don't know, Margaret, whether you think I'm being too restrictive, too lawyerish about that.
I think you're exactly right. And it's the issue we're grappling with in PSIG as well, is, you know, you can't tell people to not follow the law. You know, you're in a really difficult one, but again, I think we can apply, I mean, I hate to say it, but we can apply a little bit of common sense. And we know that if you're transferring to the Marks and Spencer scheme that invests in global equities, that isn't going to be a problem. And we've got the absolutely, silly situation that the answer for the pensions industry is to refer those cases to MAPS. What is MAPS going to be able to do? It's only going to say to people, oh yeah, you're transferring to Marks and Spencer and it's got overseas investments like every other scheme does. Therefore, yeah, no problem, go ahead and transfer. So it's a completely useless, bit of legislation, but it is where we are. And I would encourage people to take a reasonable view and trust that it will be sorted out, because it is difficult. It is difficult.
I do wonder if MAPS are going to have to get some pretty swift processes in place, so that, I mean, it does feel like you're passing the buck to MAPS, but then they say, well, okay, we appreciate that the trustees need to do this because they're required to do by law, but our processes here are going to be super quick to pass this along.
Yeah, well, MAPS won't necessarily know why something has been referred to them for guidance. So I think it would be quite difficult. But I think the problem with MAPS is that they do everything on face-to-face, not face-to-face, but they do in-person guidance calls rather than using technology. If they use technology, then a lot of people could be given a message about overseas investments and let them make up their mind. So it's the fact it's quite labour intensive for MAPS, I think, that's going to cause the biggest problem.
Yeah, I think that's right, and I can see that there might be something in your sort of green list plus non-statutory transfers, just as a practical way of just keeping things moving and not causing complete backlogs.
And I think, just to expand on that a little bit, as I said, a lot of insured transfers are done on a discretionary basis. So that means that the first thing they do is exercise discretion unless they find something looks a bit dodgy, and then they look to see if they can find a statutory right that they can say doesn't exist. Whereas trustees tend to do it the other way around. They look at the statutory right first. Does that apply? If not, then go to discretion. And DWP and the regulator are trying to stop people going to discretion to get around the legislation. So that sort of gives us a problem in trying to find a practical solution.
Yeah, thank you. And then just finally, just a sort of question, we had a few questions in around the phrase, Maddie, that you used around substantive response, that you've sort of received a substantive response, and whether that, again, sort of how to practically, any help with what that means?
Well, interestingly, I think the way substantive response is talked about in the regs doesn't actually, to me, sound like a substantive response. So I think there should potentially be less concern about the level of information that's given here. I think that reads that the members responding to you, the members giving you the information that you've asked for, but it might not yet be sufficient. So I think it's providing you've got that dialogue going on with the member, the trustees won't be raising a red flag.
Yeah, I think that's absolutely right, actually. You've got to, be a bit reasonable on it. And, one thing to bear in mind, if a member actually lies and, creates paperwork that's fraudulent, they're not going to win in any challenge.
We're just about out of time, I'm afraid. We haven't managed to get through all of the questions. Apologies if we haven't picked up the theme of your question. We tried to just pick up as many as we could there. Thank you for all those questions. Certainly the ones where people have given their names, we'll endeavour to come back to you separately afterwards. And if anyone who didn't would like a specific answer to their question, then do feel free to contact me or Maddie, and we'll certainly pick up with you individually on that. But if I may say to Margaret and Maddie, thank you so much for being with us today for that great session on this tricky practical topic. I think and I hope that people out there are heartened by the there's the comfort and the pragmatism and the fact that there's a job to do here for trustees, but we do need to all help trustees find a way that keeps it proportionate and keeps the transfers going where we can. Thank you for your time. Thank you everyone for joining us. And please, if you can, join us next Wednesday for the third and final in our Volume 1 series. Thank you very much. Have a good afternoon, everyone.